Chattanooga, Tennessee, David Tulis.
You're free to leave. Do you have a firearm in your trunk? That's what the officer is telling you there on the side of the road. He says, you're free to leave, but can you tell me if you have anything illegal in the trunk of your car? Do you have a pistol? Do you have marijuana under your seat? The contradiction should be clear to you, because you're being told one thing and then you're being told something that contradicts it. You're being told you're free to leave because the officer does not have probable cause to hold you any longer there on the side of the road. But the question that follows immediately after that permission suggests that you're not free to leave and that you have to answer his question, or that you have to deal with this question. This is a question that comes up in the case of State of Tennessee versus Gonzalo Moran Garcia in 2003, one of several cases that discusses traffic stops, that discusses Miranda warnings and the liberty of the person on the side of the street or elsewhere to deal with the officer or not, as he may choose. If you're told you're free to leave, then you need to understand that you're free to leave. And that is the question always when you have an encounter with an officer of the state, right? Police officers are corporation employees. They are city employees. And they have a high mission, as it were, to enforce the statute from out of Nashville. And they also are enforcers of ordinances. Now, that there's a conflict in the law that raises the question of whether police have authority to enforce all the statutes that are there, or whether they don't. And I'm not settling my reading on this question. So let's just say that this is in pencil only. Though if you read Nooganomics.com, the website for the man who matters, you'll see there's been an extensive analysis and review of authority of policing per se. It's extensive, but just beginning at the same time. I'm not done looking into this question of what is the true state of affairs in the law in Chattanooga and in Southeast Tennessee and Hamilton County, where you, my listener, are, I hope. And if you're not, if you're just passing through, you're on the highway tuning into 92.7 and 95.3 HD4 FM, you should be here, right? You should belong to Chattanooga. You should move here, relocate, come to Hamilton County, and enjoy the many, many blessings of this city, which are there are not too many to count, but to try to count them in any one sitting would be quite a task. Would fill up half of a notebook, just listing out some of the benefits of living here in God's providence, right? Well, the question that I'm having you look at here is one that Nooganomics.com raises again this morning. The website for the man who matters, Nooganomics.com, and that is trying to find a benefit in the legal thwarting of what's called community policing. Community policing is about a 25-year-old theory that seeks to have the state and its agents exploit humanity and human relationships by making the officer the friend and confidant, the man who fixes the old woman's fan, who secures property of property owners, store owners, and homeowners, and who is a good guy who's there just to help. Right? That's the community policing theory, that the officer is not continually shifted around different parts of town on different districts or precincts. He's always in the same one and gets to know everybody and becomes a familiar person as if he were a neighbor. Right? That's the idea of community policing. That lets the humanity of the officer fit in and flow in with the humanity of all the people in that part of town, the good and the bad, right? That way he can better know what's happening if a crime occurs. He can know whom to ask first about why this dead person is on the ground. But community policing which was stressed by former police chief Fred Fletcher, and said to be one of his strengths. It was a humanizing and warm and familial and fraternal idea, right? Is challenged by a preceding concept, and that preceding concept is the Miranda rights reading required when there is an arrest, right? An arrest is when you're stopped, when you're seized, when you are held by the officer, and when you're arrested, you're supposed to get your Miranda rights read. Now, that's not a law, Okay, it's not a law, but it's policy. And there's a difference between law and policy. Policy, it comes out of high court rulings that effectively reshape the law, where the judiciary and its edicts enforced by swarms of attorneys on every block of every city. You have the attorneys making this clear. Court cases and rulings are law. They call it case law. It's a common word for it. And what that means is that the court says that we interpret this law this way and the Constitution this way, and therefore it has an effect of shaping how that law goes into effect. Right. So Miranda protects the right against self-incrimination in criminal matters. And so the ruling from 1966, Miranda versus Arizona, has an effect of being a law. It's a law for the officer, for sure, according to the jurisprudence, and even according to a policy statement that Chief Fred Fletcher wrote. I think the date is maybe 2000. I'm not sure of the date now, but it was one that has his signature on it, originally crafted in the early 2010s. And the requirement under Miranda is, of course, the reading of the rights of a person who is arrested. But the city police department is not enforcing that rule. It's not obeying that policy, even though it's explicit policy in the rules for officers. It's not being enforced. And the fact that it's not being enforced is reflected in various policy positions, policy statements that are not in the one called arrest procedures. Other ones would be motor vehicle stops, and there's another one, traffic enforcement. I think is another policy position or policy paper, policy rule for officers, and that doesn't mention Miranda either. Not that it has to repeat Miranda, but it should at least, I would think, pay deference to that obligation in the other documents that control officers' actions, and remind the officer how we do things here in Chattanooga, right? Well, Miranda is largely ignored, not just in traffic encounters, in belligerent traffic encounters. I'll have to put it that way, but in other encounters as well. Hanson Melvin, when I called him yesterday to confirm that he had not been Mirandized, he said, "No, I wasn't." And that's, of course, the famous Hanson Melvin case that's going to go to trial in circuit court in November of, I think, next year. I'm not sure why it's so long, but apparently Jim McCoon, the attorney who runs the leading name in the legal office where Clay Whitaker is handling the Hanson Melvin case, said it's November of 2018. Well, anyway, Hanson Melvin was not Mirandized, and so that says that tells me that Miranda has lost its claim upon this department in Chattanooga. And I would say that other high court rulings also are made, and though they would seem to have some claim upon the way things run in the hinterland, in, let's say, Tennessee, Chattanooga, they don't. And you can encounter that another one of these questions about the ignored high court rulings in today's essay at Nooganomics.com, the website for the Man Who Matters. So the question is, in the officer, he says, "You're free to leave. Do you have a firearm or marijuana in your trunk?" He says one right after the other. Well, there's a question now of attenuation, and that question of attenuation comes up in the Garcia ruling. And attenuation is a way where you have an illegal stop made into a legal stop by consent. Okay, what is consent? So if the officer says, "You're free to leave, do you have a gun in your trunk?" he's saying that you're here voluntarily, right? If you don't leave when he says that, and you continue dealing with the officer's questions, and then maybe giving in and granting permission, he's going to argue, "Well, I told him he was free to leave, and he didn't, so therefore he voluntarily stayed, and everything he said to me was voluntary." Well, the question that Garcia answers is, what is an arrest? And the story, I'm here trying to update you on the whole story if you've missed out. The story is that when you are stopped, you are arrested, and that case cites the Terry decision, the Terry ruling out of the federal high court that says an arrest is a stop, is a seizure, right? They're all synonymous for the purpose of arrest. And that means that they're synonymous for the purpose of Miranda. The Miranda warning has to be given immediately, right? Once there's an arrest, that warning has to be given immediately. If you go to OPS 42 arrest procedures of the Chattanooga Police Department policy manual, You can read that on page 6, and it tells you what these warnings are to consist of. There are 5 of them. The first one is you have a right to remain silent, and the second one is anything you say can be used against you in court. And the other ones deal with the right to have an attorney, the right to have counsel, and if you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. And the 5th one is if you decide to answer questions now without a lawyer present, you will still have the right to stop answering questions at any time. In other words, just because you start answering questions and giving up your rights doesn't mean that you can stop giving up your rights and that you have to keep on giving them up, right? That's what that's essentially warning you. That's a warning that the rules of the Chattanooga Police Department require the officer to give. And then that's point A, okay? That point A in procedure to be followed after arrest. Point B says, although these warnings must be given only before interrogation takes place, it is good practice to give them immediately after arrest, thereby making any offhand remarks or any other voluntary comments by the offender admissible in court. What the police don't want is that there be, at the suppression hearing, things suppressed, right? Which means they're taken by the judge out of consideration as evidence against the defendant. And if evidence is suppressed, well, then the case goes away and it has to be dropped. What the police want is that everything be, that there be incriminating things against the defendant that they elicit from him voluntarily. Okay, so we have these two ideas. We have Miranda with a requirement for warning, and then we have arrest. What is arrest? Well, the police department, as I explained it at Nooganomics.com this morning, the police department, not just in Chattanooga, but around the country, police departments, plural, and sheriff's offices, plural, like there to be no clear line between the moment of arrest and the part before, between the voluntary part and the involuntary part. And so Miranda, we could say, is bad news for policing. It was intended to be bad news for policing. And a kind of retardant and slowing down, a kind of stifling of policing, a kind of retarding, those are the words I'm looking for. Keeping back, slowing down, reducing the power, the effectiveness of policing, right? Of law enforcement against the people. That's why it was given, because there were people being beaten by police to have confessions elicited from them involuntarily, but elicited voluntarily, right? Because you're being beaten, you signed that you voluntarily agree that you killed this person or that you carried these drugs or committed a robbery, right? So that's what happened. Miranda is intended to prevent that kind of abuse and to maintain the constitutional protections for the individual of his right to avoid self-incrimination. Well, here we are on the side of the street. You're free to leave if you have a rifle or marijuana in your trunk. And it's most people, the judges in this case say, well, that just doesn't work. You can't, the person who is, the common person is going to understand that he's not free to leave. Even though he's told he's free to leave, he's not going to believe it, because the question that immediately follows implies that the question was simply a spurious statement by the officer, not to be believed, especially if another cop car drives up, right? Then you think, well, boy, I really am in trouble. And I'm not free to leave, right? The cop's blocking my way, right? So the cop saying you're free to leave may not be true, and then the question of attenuation comes up as to the stop, the original cause of the stop. Now, don't have time to get into Garcia any more than that. But the question before us is, and I'm trying to be sympathetic to David Roddy, the chief of police. He has probably a desire to continue the community policing idea. But if the officer, his problem is that Miranda doesn't really allow for that, because Miranda always throws up a flag at the very beginning, right? When the officer he's already planning on arresting somebody, but he hasn't told him, right? The officer wants there to be more conversation with the scared person trying to talk his way out of trouble, and then incriminating himself. The officer likes that. And in his mind, he's going to arrest this guy, but he just wants the guy to keep talking, and maybe he'll find out something that he can use against him. Miranda doesn't allow that. Miranda says if you stop someone, you have to have probable cause or an articulable suspicion. Of course, there's the standard that keeps being reduced. It's now reasonable suspicion to arrest someone. It's very, very vague now. You really don't have as many protections against the good people as you used to. But there has to be something in the officer's mind articulable. He has to under oath testify that he had an articulable suspicion. or cause or reason. And at that point, he's supposed to Mirandize the person because he plans to arrest him. And the reason he's talking to him is he wants to get a confession of some kind. He wants to have a drug bust. He wants to have a DUI bust. He wants to get an admission of some kind from this person that he can use in court, right? That won't be knocked out in the suppression hearing. And he doesn't like the fact that the Miranda rule is there. So the question is, and the fact of the Miranda rule being there makes it hard for the officer to have the friendly chat, right? He can't have these sort of offhand friendly interrogations, which end up in an arrest. He just can't do it that easily. And what I think the effect of Miranda, if it were honored in Chattanooga, would be fewer belligerent police encounters. That means fewer encounters where the officer charges at you, puts on the blue lights and arrests you and says, okay, I'm taking you in, or you can sign your name on the citation for ordinances and statutes that are of the city. Now there's a separate statute that talks about alternatives to arrest, and that's the citation system, but that's only for ordinances and statutes, state statutes of the city. Okay, they have to belong to the city by some kind of adoption or claim that those statutes are of the city. Now I haven't checked on that. What crimes have been adopted by municipal government to make them of Chattanooga, right? Because the ordinance, the statute is very clear that these are ordinances, offenses that you can be cited for, and statutes that are of the city, and only for those can he give you a citation. Otherwise, he has to arrest you. He has to take you to the magistrate, so you can post bond, and then if you can't post bond, then he has to have you booked and arrested, so that you can then be bail yourself out if you have the money, right? If you have the money, if you're poor, well, you're stuck for weeks in the jail, awaiting a hearing and trial because you're too poor to bail your way out, and you don't know people to put up the money, to front the money to the bondsman who takes 10%. There are a lot of people in the jail like that. I want you to know that there are a lot of people who just can't make it. They can't get out, and they're in there for weeks and weeks because they're too poor. It's a serious problem. So the question about Miranda is this. I would say the command of Miranda is this. You're commanded to give the warning, which puts the defendant on alert. Okay, he's on alert. He better not say anything. He better know his rights. He better assert his rights, defend his rights. And if he yields, he's going to be incriminating himself, and he's in more trouble. So the problem in the police encounter is you think that if you resist and you stand on your rights and you assert your rights, somehow that you're making trouble for yourself. You're making trouble for the officer. In the long run, every time that you assert and defend your rights, you are reducing the future trouble, not increasing it. The trouble comes when he uses your flapping gums to find something as a cause against you, as a reason to implicate you, and he'll do it, right? He knows the law better than you do, and he's sworn. If we look at the ethics rules of the police department, which I've already mentioned, I'll plan to publish something on that in the next few days. Yeah, he is bound to uphold the Constitution and to protect you, right? That's under his oath touches on constitutional rights, and he's supposed to uphold those and protect those. And your property rights, your personal liberties, and your person. He has a duty under God and before the Constitution to defend those three things in his ethics rules. Well, what do we care most about in this analysis? I think we care about you first of all, your rights. We don't want you to be forced to give them up by ignorance, but rights, as June Griffin in Dayton says, rights are not self-exercising. They're not self-exacting. They have to be defended by you. You, the listener, have to be a belligerent claimant in person. That's a legal term that means you have to defend your rights in person at the moment they're challenged. You can't do it later. You can't hire somebody to do it. You have to do it right then and right there, whether it's in your business, in your house, or walking down the street, traveling in a car, truck, or maybe you're involved in transportation and you're a motorist and an operator of a motor vehicle. You too. You have rights and you can defend them, even though you've made a compromise at that point. You have rights that you can assert and defend. The officer's coming at you belligerently, right? He's coming at you. He's arresting you. When you're pulled over, you are under arrest. All right, you're under arrest. He's not going to reach your rights because he wants you to think that you're not under arrest. He's just detaining you, right? He thinks that somehow detention is different from arrest. Detain and arrest are the same. Detain, stop, and arrest are all the same. And custodial arrest is when you think you can't go, right? When you think you can't go, in the totality of the circumstances, you are under arrest, okay? Just get that down. If you're not free to leave, you are under arrest. So I always say the question asked is, officer, it's a great day, and I love the weather. Am I free to leave? If he says no, you are under arrest, okay? You can't say you're not free to leave and you're not under arrest. That's a lie. That's a simple lie, and certainly officers in Chattanooga do not lie. They will not do that. If you're under arrest, you're not free to leave. Therefore, you have to figure out right then, am I going to stand on my rights, or am I going to just cave in and say things and get into deeper trouble? David Tulis, Nooga Radio, sponsored by Nooganomics.com.
3, 2, 1.